Good evening. My name is Ron Daniels, and you're here at the Tort Reform Update panel. Here, the first panel for EFF Track at DragonCon 2025. I'm a lawyer down in Middle Georgia. I have a very general practice. It's primarily in representing governmental entities, several county governments, and some state agencies. I do a little bit of personal injury work, have done personal injury work since 2012 when I joined the bar. Some defense work, but primarily plaintiff's work, and then some consumer protection practice as part of sort of dovetailing out of my personal injury practice that I've had at various points in time. I'm the moderator tonight, and I've got two other attorneys up here. Before I introduce them and let them tell you about themselves, I want to give you a little caveat that I always do. We're lawyers. We're giving you information. We're not giving you legal advice. Therefore, you are not our clients, and you cannot rely on what we're telling you. Okay, you got it. And I happen to know that I heard in the back when I was getting here a little early that we've got some folks who work in the legal field. So raise your hand if you're a lawyer. Okay, and then raise your hand if you work at a law firm or adjacent to a legal industry. Okay, so we've got a bunch of ringers out there. We are going to take questions. The one thing about questions is you are going to have to come down to that microphone. This is being recorded. They need to be able to hear what you ask. So if we repeat your question back to you, it's not because we're just trying to stall for time. It's because we want to make sure that people that are watching this on recording know what you were asking, so they don't just hear us start talking about random things. Okay. So I'm going to start here to my immediate left is TJ. TJ, tell us about yourself.
My name is TJ Mihill. I'm an attorney here in Atlanta. I work at Stites and Harbison, and I do business and IP, which doesn't sound anything like personal injury, but my business clients are the types of businesses that get slip and falls or crimes happening on the premises, things of that nature. And so you do deal with these types of tort claims, even as a business lawyer in some cases. So it's a part of my practice, but it's not a broad part of my practice. My practice generally does business and IP litigation.
My name is Cory Rosenberger. I am assistant district attorney in the Conasauga Judicial Circuit. That is Whitfield and Murray County up towards Chattanooga. I've been practicing law for a little over a decade. I've done both public defense work and prosecution. I've done solely criminal law. I'd say that the closest I've come to torts is victims in my cases. Sometimes I'll tell them, you may need to go speak to an attorney. That's about the closest I come to practicing tort law.
So it sounds like that some of you in the audience may be even more familiar with this or how it might impact your business than we are. So again, if you want to share, ask questions, share anecdotes, we're open to that as part of the process.
And I'm going to start with just sort of a brief history on tort reform, and then we'll just kind of kick it off with some topics up here. And then if you at any point in time anyone wants to get up and ask a question, go ahead. But generally we had tort reform back in the mid 2000s. There was an effort to restrict damages, and particularly medical malpractice cases. You saw some of that get passed. You saw some of it get stripped away by the Georgia Supreme Court and the Georgia Court of Appeals over a couple of years. I think probably the biggest decision that was there was the Nesselhut decision, which sort of gutted a lot of the tort reform with respect to non-economic damages and medical malpractice cases. But what happened is, as legislatures do, the legislature changed over time, and then the last couple of years there's been a talk about doing tort reform. And particularly in light of what some other states were doing, some of the things that were being proposed largely modeled what states like Florida had done. Some of it's copy and paste, some of it's not. And what we wound up getting is a bill that was passed this past session that really dynamically changes plaintiff's personal injury practice and does several things. And the thing that we sort of agree on talking about first up here is negligent security cases, because that was really, there was a whole body of law that really wasn't written down.
Right.
We developed these third-party claims in places like some of your clients. And so, TJ, do you want to talk about generally those and what has happened to those?
Sure. So let's talk about what they are first, right? A negligent security claim, a business entity, whether it's a retail business or a gas station or a hotel. Something happens on that property. And what in a negligent security case happens is there's a crime on the property. Someone has robbed you, assaulted you, murdered you, something like that. And the suit in that instance is against the property owner because they didn't properly protect you from that third party. And that third party is usually not part of that consideration. They're part of the consideration in that they're the reason that the crime existed, and there's some fault that can be sent there. But at the end of the day, they're not going to be a party to the case. The party to the case is going to be the property owner and the injured person or the deceased person's family, who is then bringing a claim on behalf of that person to say that you didn't do the right thing to protect me. And what a plaintiff had to show was that the landowner had some better knowledge than the person who was injured, that there was a likelihood of that crime to occur. And there was a multitude of cases deciding what type of law what type of crime would tell you what other crime might occur, what type of knowledge had to be had. But it was all case law. And so now we've got a brand new shiny premises liability statute. We've got a brand new cause of action that has been codified in this tort reform statute to replace all of that and make it even more difficult for a plaintiff in that situation to be successful.
Well, and let me ask your perspective on this, because, as someone who has to at least maybe not defend those businesses, but at least be in-house counsel or outside counsel and counsel them with respect to their insurance, from the perspective of what a business owner, a property owner should do, for instance, let's say hotel. We're here at a hotel. Let's say, what would you have counseled a client previously they should do to ensure that they are protecting their patrons? Number one, but number two, ensuring that they don't have liability for something that happened on the premises, like a crime occurred.
Well, buy good insurance. That's the easy answer, because then at least you have some other pocket to dip in that's not yours. But not all insurance will cover these things. That's another thing we ran into. That's how I end up being involved a lot of times is trying to challenge a denial of insurance coverage for an incident that happened on a property because of some third-party exclusions of coverage. And it is a challenge to make sure you have a property insurance policy that actually covers the things that you're likely to be sued for on your property. So get good insurance is the best advice I can give anybody. Beyond that, you want to take reasonable security measures. You want to make sure that your lights are on. You've got lights in the parking lot. You've got proper working locks. You've got security guards if security guards are appropriate in your area. Know where your business is. If your business is in an area that you should probably have a security guard, hire a security guard, maybe hire two. If you have a reason to think that this part of your property might be at risk for some kind of behavior, put some video cameras over there, put some lights over there, make sure there's something there. What I don't do is counsel my clients to go look up police reports and learn what crimes exist and try to better their knowledge about those, because again, that's the kind of thing that a plaintiff's attorney is going to come in and want to really hammer on is what did you know, what should you have known about crime, not just on your property, but in the area broadly around it. And it has been a big part of premises liability litigation to argue over what crimes have happened and can you connect that to the crime that did happen. Now, if you got shot and there's been 6 shootings at the property, that's going to be something that was connected. But if you got shot and there's been 6 car break-ins at the property, does that work? Is that knowledge of crime? Is that crime related enough to the crime that you were harmed by to make me alerted to that possibility? So those are the kinds of things that we counsel people, but also try to be aware of the risks.
And you said one thing that I think really ties to the elephant and for the whole issue is insurance and getting insurance that actually provides coverage. I think everybody would generally agree that the biggest driver of why this was done was we were told that it's going to help reduce insurance rates.
Right.
And Cory, you deal with some of this in, you're prosecuting folks when they commit crimes at properties. But insurance can only do so much. Prosecution of a criminal defendant can only do so much. And you suggested that the third party that actually commits the bad act, they're not in the lawsuit. They're dealing with Cory.
Right.
Do y'all want to elaborate on why that is?
Well, usually this comes as a surprise to no one, but a lot of times people who are mugging people, committing crimes, generally do not have a lot of money. And so I can sue anybody in this room. Well, probably wouldn't win, but it all depends on if they actually have money to recover. And a lot of these people have nothing to their name, no assets, diddly. So there's really no point in going after the actual person who did the actual assault, because probably 99 times out of 100 they have no cognizable assets whatsoever.
That's true not only for an assault occurring, but somebody driving without a license rear ends you, right?
Mm-hmm.
I mean, you can prosecute them, but you can't make them have insurance.
Yeah.
Yep.
From the perspective of the policy standpoint of trying to reduce interest rate, I mean, not insurance rates, not interest rates, though interest rates probably do need to be reduced. That's a different panel. TJ, are you seeing anything with your clients that they're getting a benefit from reduced insurance rates?
I'm not seeing that yet. So
I know it's only been a month for some.
Yeah, but that's the thing. It is not a direct cause and effect so far. Let's put it that way. If you have a question, you have to come up to the mic.
Yeah, come on.
We definitely want your question, but it has to also be recorded so that people watching this later can hear.
I would say it was interesting to me that I think it was today that the House or the House and Senate study committee met for the first time on the studying insurance rates and how to deal with rising insurance rates. The same day we have this panel.
Just approaching this from the perspective of theoretical interests, I can see why there might be concerns over having an excessively wide range of what a business might do and the legal liabilities they might face. And in some other industries, you end up having things like a generally accepted set of practices that if you follow them, then you have a certain amount of shield against bogus lawsuits and things like that. Would this be an area where it would make sense to codify good practices in order to ideally completely make certain types of lawsuits impossible, and to bring up the standard of care that would be given to consumers so that it isn't all handled in the courts?
The challenge with that is that law deals in maybes. And it's difficult to say that this set of facts will be a good set of facts in all circumstances. I gave some examples of things I might advise my clients to make sure that they're taking reasonable steps for security. Have lights in the parking lot. Not every place needs lights in the parking lot. Not every place has a parking lot. Not every place has a parking lot where anyone would be loitering in a way that could be problematic. So that might not be a reasonable step for them. That might be an expense that is unnecessary and is not, in fact, improving anyone's safety. The same with any of the other topics that I covered. So the challenge with saying that if you take these 4 steps, you have by definition taken reasonable precautions to keep your patrons safe, is that those are so fact specific in each individual property that it's impossible to lay out a defined, this for sure will fix this.
I'm going to shamelessly segue because insurance, you mentioned, plays a role in this. One of the parts of the law that didn't get a lot of public commentary was the fact that there was a section which specifically says we're overturning the collateral source rule. Could you please, first off, describe the collateral source rule, and considering Georgia's history of it, describe sort of what impact it may have, or whether or not the courts are just going to toss that part out?
I think it's too early to tell you whether or not they're going to toss it out. I think there's really good arguments either way. And I happen to know from friends that practice on both sides of the V, as we say, that they're looking for the test cases to bring to get that to the Georgia Supreme Court. So, I think it's too early to say. I will say this. I think you can look at what some other states who are similar to Georgia who have passed similar things. I think you can look and say that that's a little persuasive. And so, but the problem with that is it's kind of all over the map. So who knows is the bad thing, but I'll let you explain the collateral source.
So, well, I want to talk about the legal issue too, because at the same time, that was one of the points I wanted to make when we're coming in here, is that we have a statute that is brand new, and in the process of the last tort reform, we talked about that last tort reform showed up with follow-up cases that adjusted and changed the panel, the statute dramatically. And that's for sure going to happen again. It just is. And how fast that's going to take. What we're telling you about here today is what was written on paper, but what we are going to be dealing with in 2 or 4 or 6 or 8 years is probably going to be very different than what was written on the paper. And what we learned from that last tort reform is that it took years to really see what the outcome of that was. Now, I'll tell you, I'll be candid, I don't know what the new statute said about the tort reform rule. Could you come back, or the collateral source rule? Could you let us know what they've done with that?
Well, I mean, let me explain it, and then you can tell us what it is. So the collateral source rule is a general prohibition on introducing evidence that a plaintiff's or any individual in a case, really, but it's geared toward plaintiff, that they received insurance compensation basically for their medical treatment. So you didn't know, you just saw the bills. You didn't see that Blue Cross Blue Shield, Anthem, Aetna, whatever the company paid a third of whatever the charge is. You saw just the total bill.
Right.
And that was what Georgia law said. And so I'll let you lead us.
Yeah. So what changed? I'm not aware of that.
In the bill, basically, the specific portion that deals with medical damages specifically says you get to see both numbers being what was charged and what was paid.
Oh, so you get to see what was paid now.
And specifically in the bill itself, it says this is directly against the collateral source rule and we intended it.
Yeah. And I will tell you, my biggest heartburn with that does not flow from any personal injury case that I've worked on, but it does flow from the consumer protection cases I've worked on, because I understand very deeply charge masters and how hospitals and medical providers bill. And I understand that the Medicare, Medicaid reimbursement rate is basically it's not the gold standard, but for purposes of describing it's the gold standard. That's like what everybody falls in line with, is whatever the Medicaid, Medicare reimbursement rate is, because a lot of these medical providers rely on that stream of income. And so when Aetna or I don't know a whole lot of insurance companies, y'all. Insurance company ABC goes and negotiates with a provider. What is our reimbursement rate? They rely on that Medicare, Medicaid reimbursement rate to sort of say, well, you get this from the government. And so when you start talking about, well, these people are getting charged this, but they're only getting paid, these providers are only getting paid this, so your damages are only really that. That's the argument that you'll only get into. The problem with that is if you go to the hospital right now, pick any of them, Grady, Wellstar, any of them. I'm not picking at any of them, but go to any urgent care. Tell them you were in a car wreck. Tell them you have health insurance, and they're going to make you fill out a form saying what the insurance was in the car wreck, not your health insurance, because they know they get more money from that than they do from Medicare, Medicaid, Aetna, Blue Cross Blue Shield, any of those. And so you got this sort of, we want the most money in the healthcare industry that we can get. At the same time, we want to reduce the amount somebody can actually recover. And that just reduces the pot of money that is there to pay those healthcare providers,
Right.
to pay for your damages, and to fix your car.
Well, because that's the thing. One of the things that comes out of this, one of the reasons we don't tell people about insurance in a trial is because you're not supposed to know somebody's already been paid, right? Your damages are your damages. And if insurance has already covered some of those, well, you haven't really been damaged, have you? You haven't really been harmed by that. But that being said, when you would get that, whatever judgment you got, a lot of times you'd get a letter from, the ambulance who took you to the thing, or the helicopter that life flighted you out, or the insurance company themselves. Hey, by the way, we paid this. You should pay us back out of that judgment. So that is something that if we start reducing what people are collecting, anybody who's looking to collect back is going to be coming out of that much smaller pot. But it is a situation where, what is the point of tort reform? The whole point of tort reform, and I say this as someone who primarily works with a defense in this instance, the purpose of tort reform is to reduce judgments. We want to make judgments smaller. That's not always the best policy, but that's what the whole purpose of this tort reform is to do. It's to minimize what damages are there and to get rid of runaway judgments and runaway juries. And one way to do that is to say, well, instead of being able to say, I have $800,000 in medical bills, well, but you really only paid $175,000, Ron, so maybe you don't really need to get $800,000 in a judgment. I mean, again, right or wrong or otherwise, but that's what the concept is going for here. I didn't realize we were getting the actual numbers now. I didn't see that part of the.
Well, we're lawyers. We do math really well.
That's right.
Oh.
I'll let somebody else math for me.
One thing that's interesting to me, and I think may be a salient argument at some point in time on one side or the other, is some of the concepts that you see in what ultimately passed look a lot like criminal trials. And I don't know that people really seized upon that, but two things in particular is there's now this bifurcation of damages that's mandatory for cases. And that's interesting to me because, yes, it does prolong trials a little bit, but I don't think it prolongs trials necessarily that much. I think it's probably the ultimately same amount of trial. You just might get a little bit more argument. But that is a concept that Cory is very familiar with, because Cory will tell you, Cory, what happens when you have somebody that's charged with possession of a firearm by a convicted felon along with something else?
So I had a really fun murder case once. It was a week-long trial. Murder, aggravated assault, possession of a firearm by a convicted felon was one of the charges. But so we come to the climax. I give a closing argument on murder. He's found guilty, and then I have to have another little mini separate trial after he's been found guilty of murder for possession of a firearm by a convicted felon. Because the idea is that if the jury hears, oh, well, he's a convicted felon, they're more likely to use that against him in the murder trial. And so you have to separate the two things and do the one that prejudices the defendant last. And so yeah, I got to have a very anticlimactic 5-minute trial on possession of a firearm by a convicted felon, where I just tender a certified copy of his conviction after he's already been found guilty of murder. But that's kind of the idea of a bifurcated trial.
And from my practice dealing with particularly consumer protection statutes, that we have this concept of fee shifting statutes. And so it's not uncommon for us to have bifurcated trials. I mean, that is more common. And a lot of times it can be a tripartite bifurcation where we have to present evidence as to liability and actual compensatory damages. And then you get to like the Georgia Fair Business Practices Act, where you can treble your damages or punitive damages under a different name. And then you have a mini trial of that. And then guess what? Because the statutes say that if you prevail, you're entitled to an award of attorney's fees. You get to have a trial on those attorney's fees. So, I'm used to that. I think that's probably one of those things that if I had to guess, I think is probably going to wind up sticking, is the bifurcation parts. I don't think there's really great arguments. I understand the logistic argument against it. I don't think there's a really good legal argument to overturn it.
No, right. I think that's it. It's again, talking about the goal is to minimize your judgments, minimize the amount of judgments, but also minimize the judgments against you. So if we're going to talk about just pure liability, here's the thing that happened, and here's the thing that we did that we thought was, appropriate and reasonable in that circumstance. And in a vacuum, it can be much harder to say, oh, that sounds like that was probably pretty reasonable of the defendant to do, or, oh, I think the plaintiff probably wasn't really all that injured in that circumstance, when you're not hearing the fact that there's $800,000 of damages from medical bills, or even legitimate medical bills, paid medical bills, whatever you want to put in, that arose from this. Some things don't sound like they're all that bad until you realize that somebody was really seriously injured by it. And so there's a reality in these bifurcations where you're found not liable because the jury's sympathy isn't there. And that, again, from a legal standpoint, that might be the correct outcome. It's hard to argue that it's not, if you're not liable, you shouldn't be paying just because someone got hurt real bad. But that's what flavors jury trials. That's what causes juries to get more sympathetic towards plaintiffs. That's what gets juries to be more likely to find someone liable, because now I've heard those more emotional parts of the case.
And I think generally across the board, we try to take the sympathy out of it from a liability perspective, even a criminal liability perspective. I mean, the jury charges all say you're not supposed to allow sympathy to influence how you ultimately rule as a jury. But I'll tell you, having tried criminal cases and having tried civil cases, juries somewhat scare me. I don't ever really feel like I know what a jury is going to do. And I've had some really good cases, and I have walked out wondering still to this day what happened. And then I've had cases that I took pro bono that I thought for sure I was going to lose, a homeowner's insurance case. And after 2 hours of deliberation, they sent a note out to the judge, can we award pain and suffering? And those are moments that are rare in my life, but you don't, juries, it's interesting what they seize upon and what they perceive and what they base their decisions on. And so trying to take sympathy out of it does make some sense to me. And I think we tried to do that. And I think, whether rightly or wrongly, if that's a function of the tort reform bill or not, but I think it does do that with the bifurcation process, as you alluded to.
Yeah.
One thing that's interesting to me, and probably hits me closer than anything, Cory, you don't have any state courts up there, do you?
No.
All right, so Cory would probably see me a lot in court because I have a problem wearing my seatbelt. I am a country bumpkin from Dodge County, Georgia, and I grew up riding in the back of a S10 with a John boat hanging out the back of it, going to the river. So I was offended when they first said that seatbelts were mandatory. I understand why they're important for safety concerns, and I do wear them most of the time. But if I'm going to travel around town for 3 minutes, I usually just let it ding at me. And up until now, if I was not wearing a seatbelt and I was in a wreck, guess what? You could not introduce that in evidence, but now it is. So what's your thoughts on that?
I don't know. I wear my seatbelt. So.
I'm just a lawbreaker. I'm a rebel.
Well, again, it's like the question of the premises liability, right? We're trying to say you have taken some responsibility for your own harm here. You were more injured because you weren't wearing your seatbelt. I shouldn't have to pay for your damages that would have been lessened had you been a good and law-abiding citizen. So that's the theory behind it. But it's you can go back and read all the reasons why we weren't allowed to say it before, and you can see what we're doing now. And some of this is just, I think, some of this is just legislators spitballing and seeing what has worked other places, seeing what they can get to stick, seeing what they can try and put in and make fly to find ways to drive down the judgments. But it is, it is a factor of the process. So.
Surprisingly, that is one of those topics, though, that you would think would be very inconsequential. But for me, it was holding up a lot of tort reform. Like, that was a very hotly debated issue for years and years and years, until recently that they got enough people on board. And so I understand. I come from a place where there's a lot of people on farms, and you don't really wear a seatbelt around the farm. And if you cross the road or go 2 miles down the road, sometimes you don't put the seatbelt on, and it's a bad idea to ride around in a car or truck without a seatbelt. It really is. But I do it.
Right. Well, but then again, you when you're looking at it, you're like, okay, well, let's take the case. I was driving my farm truck across the road, didn't have my seatbelt on, drunk driver T-boned me, and now you're going to tell me that I shouldn't, be made whole in a judgment because I was not wearing my seatbelt, and I should be partly at fault. And you can see where the characterization can go both ways.
It's just going to take a whole heck of a lot of truck to throw me out of my car.
Yeah.
I mean, I ain't getting out of there too easy. I can barely get out of there now. So let's talk about the insurance, because I do think that is a primary driver of why we were told that we need this, to combat these judgments. The insurers don't want to pay it. Let's talk about, though, from the practical standpoint, do we really think those judgments were what were driving insurance rates up?
Well, so that's an interesting question, because the judgments can get huge, and judgments can far exceed the cost of trial. But cost of trial is not insignificant, even when you're doing it at insurance rates. The amount of money spent defending these cases is not inconsequential. And if you're talking about what's going to affect your insurance rates, I mean, how much money do they have to spend out? Well, they're spending out a couple $100,000 on defending something, and now we're talking about a bifurcated or trifurcated process. So we're going to try the case, and then we're going to try the case again, and then we're going to try the case a third time to see if we're going to get attorney's fees or punitives. We're going to try the whole case over and over, but it is far less efficient than doing it in one lump. So is the judgment affecting your insurance rates? I mean, yeah, probably somewhat, but it's not the main issue.
I have a hypothesis, and I want to see if you agree with it, and see if Cory agrees with it. I think one of the things that's driving insurance rates up to that end is the fact that minimum limits is $25,000, and you cannot replace most cars now that has moderate damage with $25,000.
Yep.
I think that's probably one of the biggest things. You would think having increased rates would have the opposite effect of making rates more expensive. And to some degree, it does have to. But, when you have, when you can't replace a car and you've got to subrogate and go on your insurance because, somebody hits you with $25,000 and you've got an $80,000 truck. I mean, the price of vehicles is insane.
Yeah. Well, that's true of everything. So yeah, it is. To me, there's so many factors that are not going to be altered by anything we have done here in Tort Reform, as far as what your insurance calculations are going to go.
You're not allowed to ask a question.
And it's only because I'm wearing a Wolfram and
It is.
No.
Respectfully, I think you're comparing apples and oranges here because you're talking about property damage, which is potentially covered under UIM policies, which is an entirely different beast altogether, assuming you've got in this case. What we're talking about here, mostly in terms of disproportionate verdicts and its relative play as to insurance rates, has to do, and I haven't heard you mention the word halt yet whatsoever, which is what I've been waiting for on all of this. And it has to do with the demands made. Respectfully, main limits insurance have nothing to do with this whatsoever. An insurance company gets a claim that you have medical damages that are more than $25,000, which is essentially every claim now made. They're going to pay the claim regardless of the liability on it, unless maybe it's Allstate or State Farm. That's a whole other story. But what I haven't heard is things like sublimits and exclusions for A and B and how those are playing into it. That is the driver behind all of this. And respectfully, I think you've been kind of dancing around the pinhead and not talking about what is really the driver behind all of the things that were in SB 68 on the first place. And that has to do with the disproportionate verdicts and their effect on the ability of small businesses to get insurance in the first place. That either doesn't have a sublimit or doesn't have an exclusion that applies to it. That's what I would like to hear you all talk about, is the experience on that point.
So I just don't think, okay, I don't disagree with your point, but I'll tell you that when I was first starting to practice law 20 plus years ago and was dealing with businesses, all of those businesses had policies that had some limits and exclusions. And again, my practice is in primarily premises liability in these things. And every single one of those had a third party action exclusion. Every single one of them had something in there that would undercut coverage. And fighting coverage was 60% of the process.
Was not the job of the liability attorney whatsoever.
No. That's how I got involved. Because I didn't work for the insurance company. I'm not the one that gets hired to defend it if there's defense covered by a policy.
Now, respectfully,
So
I am.
right, and so your position is very different. But I have a firm full of partners who do the same.
Yeah, that one lives across the street from me, actually.
But the sublimits. I mean, again, we know that this is not my area. Sublimits have been a thing in policies since policies have existed, and trying to not pay claims is the goal of most insurance companies.
Oh, no, I disagree with you 100% on that point. And that's part of the misinterpretation that goes on constantly. I have never met an adjuster who tries to not pay a claim. And I think that's part of the miscommunication that goes on. And that's part of, I hate to use this phrase because it is so charged prejudicially, the notion of that's social inflation. It is a plaintiff's argument to say insurance companies don't want to pay claims. No. Insurance companies, in my experience in the 30 years I've been doing this, want to pay the reasonable value on claims.
I would phrase it a different way. And I think you would agree with this. I think that the insurance adjusters that I've interacted with just don't want to exceed the reserve.
Depends on the analysis that's been done.
Right, but I mean, that's the whole thing with insurance. I don't view insurance as an evil. I think it's a great thing. But I also appreciate that insurance is just like health insurance, car insurance, property insurance. It's all a form of essentially betting. It's legalized gambling, and they are hoping by saying, this is the risk associated with you that we are going to make a profit, and that's great. They are allocating risk and setting their reserves, and when something happens, they set a reserve, and that reserve can change as depending on facts and depending on what they learn. But I don't view it as an evil. But I think we're probably not getting too much of a disagreement there because we're just using different words to phrase what they're doing. But it's like you said, they just want to play what they think is reasonable.
Right.
See, the difference of perspective there, though, is this. I work for a firm now that has plenty of insurance companies that hire our attorneys to provide these coverages and do resolve claims and do pay claims when they're made. And there are certainly concerns to be raised about the size of some of the judgments that have been handed down in recent years. But I've also worked with coverage counsel whose goal was to not pay claims. I mean, that at the end of the day, there's an entire law practice built around those exclusions that we're talking about.
I will, TJ, I'll respectfully disagree with that, especially knowing that my firm has an entire coverage section. The notion is to analyze the claim and does it fall within coverage of the contract. It is not to find a way for the insurance company to get out of the claim.
Fair, correct. But at the end of the day, those exclusions exist and they're put in things. We've had many clients who didn't, you read the policy. You're held to have read the policy, but most business people don't really read their policy. They don't know those exclusions exist. They're paying insurance. They think they have insurance, and suddenly they find out that we don't have that insurance. And that policy that we bought expressly to protect our business doesn't benefit us for the one thing we thought we got. Again, that's a problem with them. That's something they should have talked about better with their agent. That's something they should have talked about better with their insurance broker. Whoever got them that insurance didn't do them any favors. But it doesn't change the fact that these exclusions have, again, been there since the dawn of time. These sublimits have been there. People are being held to those sublimits, and that's pure contract. I mean, you bring me that contract, I'm going to enforce that contract.
Mm-hmm.
But it doesn't. When you say the exclusions are going to be an issue, exclusions are already an issue for most of these cases.
I'm going to turn the gears on you for a quick second and just take it away from this to go back to something you said earlier. And your answer may be, I don't know, based on what you said earlier. One thing I haven't heard you talk about is the effect of lien-based treatment. There you go, Ron. Lien-based treatment on these disproportionate verdicts. So I'm going to step away and let you talk about that and how this was supposed to affect that one way or the other. And I'll give you bonus points if you mention the names Champions or Rescue in this conversation.
I'm not going to mention those names, so you're not giving me bonus points. But so liens are just this. Liens and litigation funding are just things that drive me crazy, because for the large part of legal history, we had this idea of champerty and maintenance, which is really old common law terms for you can't basically just, I can't say I really don't like Scott. And so, but I don't want Scott, Scott's not done anything to me. I just don't like him. So TJ, I want you to sue Scott. You be the plaintiff. I'm just going to bankroll this.
Mm-hmm.
That was, that's what the law was. I have successfully beat up on debt collectors with that. It's great. But in the last decade or so, perhaps longer, you saw these companies that pop up and they would, give people cash advances on their cases and things like that, and then they would get a lien on it. Well, those people also talked to medical providers, and those medical providers saw, well, everybody comes out better if, this person has $30,000 in medical bills rather than $10,000 in medical bills. So they start running up bills for things. Now, I think there's a critical, cynical view of it that all of that is always treatment that's, just over proportion, blown out of proportion, things that are not necessary. I don't know that it is always. I don't know that it's always necessary. I don't do enough of it to really tell you that I've looked at enough of them to know. But I do know I've seen horror cases on both ends of the spectrum. But I do think that those sorts of lien providers that sit there and say, well, we need to maximize our recovery, so you've got to get this treatment when that's not what you need, that's problematic. And I mean, that is driving up insurance costs because you are paying claims that you didn't have before.
Well, that was, and I do know those names. but I won't mention them either. But that is the not much more to say about the lien practice. The idea of a doctor performing treatment, providing treatment with a goal to litigation changes the outcome, right? If you're going to a doctor and they're going to treat your medical issue, they're going to treat your medical issue. And if you go to a doctor who, with a medical issue that could lead to litigation, there are good professional medical doctors who will treat your medical issue, and whatever it is, and however they would have treated it any other way. But it's kind of like the point we made about people get treated differently if you have insurance or you're paying cash. Well, if you come into certain doctors and certain medical providers, certain chiropractors with litigation as the end goal, it can be a very different treatment plan than would have otherwise been provided if you went to the urgent care across the street and paid cash.
Well, I think that some of that too is an industry that was born out of just trying to drive recovery. And whether we like it or not, we all have to wrestle with the fact that the practice of law is a little bit less of a profession than it was 50 years ago, and even less of a profession than it was 25 years ago. And some of it's client problems, and I'll throw it off on clients, and I'll say that because clients now expect their lawyers to be more accessible. They expect results faster than they did before. And as a profession, we did not say no. We said, okay, we'll adapt to that. We'll use technology. We will be more accessible, but we also will advertise more, and we'll try to get more clients and show, hey, look, we can do more. And I think that's part and parcel of driving all of that, is that we let it become less of a legal profession. And that's not really the point we're supposed to be talking about here, but I think that is part of it, is that people now want results immediately. They don't want to wait to see an ortho in 6 weeks because they have a knee problem or a back problem. They want to go to the chiropractor immediately and get treatment, or go to the masseuse, or go wherever and get treatment. More questions?
Question I have, just for the sake of gentleman who asking. I know that he was saying that he doesn't know any adjuster that is trying to settle for less than limits. Are you?
I think what he said was that he doesn't know an adjuster that's not trying to resolve a case for a reasonable value.
Right.
So are we talking about the litigation adjuster or the pre-suit adjusters? Because I've been a case manager for a while, and I've had more than my fair share of cases. And yes, Allstate, State Farm, they're their own thing, but cases where they will try and they'll try and make their own reductions.
I will tell you that he's probably referring to both, just based on his practice and me knowing him. He deals with both. Is that accurate? Okay. I do think you have to look at everything in a quantum. Okay. There are some really bad insurance companies out there. Okay. There are some really good insurance companies out there. They're bad actors and everything. Cory doesn't have a job if there's not bad actors. TJ and I really don't have jobs if there's not bad actors, okay? I mean, there are bad actors everywhere. So you're going to have some things on this end of the spectrum that give everybody a bad name. You're going to have some on this end of the spectrum that always do right. And that's just life. I mean, it's the way it is. It's just life.
Mm-hmm. And again, like I said, one of the first things when we started this panel, and the question was, what advice do I give my clients? The advice is, go get good insurance. Go get insurance for this, because you're going to want that to be there to cover you. And that coverage does happen. But I've had plenty of clients get bit by, they bought coverage from a not great company and got ridiculous exclusions in the policy that just make no sense. And suddenly they find themselves completely unprepared to deal with that consequence. So insurance is not a bad thing, but it's a business.
Yeah. Question.
Well, I am a coverage attorney, but before that, I was an underwriter. And I want to kind of, as we close out here, move to one of the public policy rationales for tort reform, and because we haven't really talked about it, especially negligent security issues. There are in every state certain high crime communities which need more development, and one of the underlying public policy rationales was that these new businesses, when they're founded, when you build a CVS or an apartment complex in an area that has high crime, you naturally know that you have a higher propensity for shootings, bad acts to occur on your property, which then exposes you to negligent security. We're looking at cases that are 5 mil, 6 mil, 7 mil, and these CGL policies, commercial general liability, those who don't know, policies only cover 1, 2 mil in aggregate. You can buy excess policies, that's true, but you're not actually going to be able to acquire them without substantial sublimits or exclusions that apply. And without tort reform, and while facing these 5 million policies, you can't open a CVS without full coverage. You can't open an apartment complex without full coverage. So for actually being able to build private businesses in these communities, what is your alternative towards tort reform to solve that issue, if not this?
So I have I'm the one who's working with those businesses. So to me, I have always had an issue with pegging the landlord or the landowner with the actions of the criminal third party. The business owner is there trying to provide a business, a service to the community, whatever it is. The community is there trying to use that service and benefit from what is there. And someone came in and stabbed somebody or shot somebody or mugged somebody or raped somebody, and they've ended up in Cory's hands and they don't have any money to pay, and someone's got to be, on the hook for that. So they look to the landowner. It's a difficult situation to be in as a business owner, to think that I might be responsible for some unknown third party's criminal actions. And I don't know that there's a good answer for that. I don't know that there's a way to say, what do you do? I also the New Premises Liability Act makes it much more difficult for plaintiffs to be successful, but is that going to stop the suits? Is that going to stop the defense costs? I don't know. Is that going to... It's not going to prevent the issue. I mean, it's not going to make premises liability or negligent security cases go away. It puts maybe better guardrails. We'll see how many of those guardrails stick when they get before Court of Appeals or Supreme Court. But I just don't think it changes the analysis of, if you're going to be a business owner and you're going to locate your business, wherever you're going to locate your business, you need to be aware of the risks of your business. And those risks, they're not going to go away if we make a different statute.
Next question.
So you've mentioned the advice of having good insurance several times. And I deal with a lot of insurance because I'm on 2 different boards of directors of nonprofits, and I have a small business, so I deal with 3 different insurances. How does one determine if one has a good insurance?
Read your policy.
Read the policy.
I mean,
It's the whole thing.
Here's the thing. I mean, the reality is, again, is what we were talking about today. Insurance is a contract, and your contract ought to be enforced. It ought to be enforced the way it's written. But it is on you. The law presumes that you will have read it, and the law is so often wrong in that presumption, because we don't read those things. They're long and they're boring, and we don't really look at it.
Case in point, it is probably the most humbling thing that I've experienced in the practice of law. But I had a fellow attorney who told me about a question they had, and they did not realize what their malpractice insurance policy said. And you would be surprised how many lawyers do not read the entirety of their malpractice insurance policy. Read the entirety of any policy you get. You're paying money for it. Read all the pages. You pay for those pages.
And when you're going and buying insurance, let the people know what you're trying to work, because it does you no good to save a few dollars on a policy to find out that policy doesn't, in fact, cover the thing that you are most at risk for. And that is unfortunately, again, it's a very common thing to have happen. One of the exclusions will exclude the type of thing that you are most at risk for in your business, but you bought it anyway because it was a way cheaper policy. Well, that's why it's a way cheaper policy, because they're not going to cover these types of claims. You're going to get those denials. They're not going to provide you coverage for that. And that's not a bad that they didn't offer it to you. It's in your contract. They're denying your coverage, but not because they're evil, because it's just not there. They gave you a policy that doesn't have it, and you bought that policy.
We got time for one more question.
Well, I guess I have to pick between the two questions I wanted to ask. So, personal injury, plaintiff's attorney, litigation. As far as reasonable value of medical care and health insurance coming in, when we settle those cases without going to trial and get those bills reduced on the back end, what we put in the plaintiff's pocket is what they consider to be their pain and suffering. Do you think this is going to lead to more cases going to trial if we can't settle for less, or if we can't settle for just the straight billing amount? And do you think that we have a massive expectation issue with all of the advertising and branding, with the billboard saying my lawyer got me X amount of money, and they all think they're going to get money in pocket, but if we're really just paying their medical bills, which I understand that a personal injury suit is not a payday, but I think we're facing a huge shift in what we're going to be dealing with as far as clients go. So
I don't think so. I think there's a huge problem with expectations.
Yeah.
And I don't know that it's just limited to this setting with clients, but I think there's a huge expectation problem, and that some of it is what they see on TV, what they see not just in advertising, but on Law and Order or LA Law or Suits and other shows. Like, I think people have just a very bizarre view of the United States legal system. I do think it's a problem. I do think there has to be a reckoning between what people are being charged for medical treatment and what they're getting in personal injury suits and personal injury claims, and what insurance is going to pay. And I don't think this fixes it. I don't think one legislative session is long enough to fix it. I think it's a multiple industry problem, and I think there's got to be some sort of reset with how we value medical treatment, just because of the way medical treatment has gotten in terms of cost and in terms of preventative medicine versus treating the problem and those things. But I'll let somebody else answer too.
No, I couldn't agree more. I really think that, again, the expectation question is just, I have clients all the time who come in and we're in litigation now. Well, when do I get to go to court? I don't know, 3 years from now, maybe. It's you've got months of discovery, and then we've got motions, and then the judge is going to take several months to rule on that motion, and then we're going to take whatever the next step is after that has gone down, and the judge is going to take several months to rule on that too. Cases just take time. Courts are busy. There are a lot of cases out there, and people don't always appreciate the process that goes into that. Nor do people often anticipate the cost that goes into that. And in some of these types of cases, that's not an issue if you're dealing with a contingency or you do have good insurance. But the public perception of the time and cost of litigation is incredibly skewed. And I think we also have so much perception problem, not just in the my client got me, $10 million, or my attorney got me $10 million ads, but the negative skew. We still talk about the McDonald's hot coffee case in law school. And everybody in the public perception has one very specific view of that case. And everybody who, understands the actual legal framework says, oh, maybe that's a very different thing than the public perspective.
And we're out of time.
Yeah.
If you would thank the panelists up here with me, give them a round of applause. Remember that you can rate this panel in your DragonCon app. Also, thanks to our special guest co-star, Wayne Melnick. who joined us as a special guest co-star panelist. So thanks for coming. Hope to see you again.